You will recall that Judge O'Connor put out 2 reports. The first report was on fact-finding, as he pointed out, dealing with such things as irresponsible sharing of intelligence information, not assuring the accuracy of intelligence information, so on. That was his first report. The second report he made a very strong recommendation for a comprehensive system of oversight and review. By the way, in his in the work under his commission, he found that there were 24 agencies under the federal government that were directly or indirectly involved in security and intelligence, and that there were 247 sharing agreements for sharing within Canada and sharing abroad. And consequently, of course, all of that led to his recommendation for a comprehensive oversight body. He found that of those 24 institutions, only a few of them had oversight, and those that did, they varied in their mandates and in their powers. For example, CERC, which oversaw the CSIS, it had certain powers and a certain mandate, but the Commission for Public Complaints with the RCMP had different ones, and then there were different ones for the Communications Security Establishment and so on. And consequently, of course, he saw that there were breakdowns, especially with the joint operations that these different bodies had, not only within the federal government, but with provincial and municipal police forces in Canada as well. So, we finally got Bill C-42, which is not yet implemented, but has been assented to, but it is still not in operation, and it's only for the RCMP. It's a far away, not close at all to what Judge O'Connor recommended. So I will now turn to our 2 panelists, and the 2 panelists that we have are first Craig Forcese. Craig is an associate professor at the Faculty of Law at the University of Ottawa. He teaches public international law, national security law, administrative law, and public law. And much of his present research and writing relates to national security, human rights, and democratic accountability. And recently, he has focused on law and national security surveillance, especially intelligence sharing between security services and cyber surveillance. And Craig will go first, and then we have Gar Pardy, and in my notes, respecting Gar, I have it, Gar is a son of the rock. That's not Alan, that means Newfoundland. You're a Newfoundlander. Well, it's good to have a Newfoundlander on the panel. And he had 40 years service with the Foreign Service of Canada and the Meteorological Services in Canada. During that period, he had frequent and ongoing relationships with security and intelligence organizations, both in Canada and abroad. And since retirement, he has been a frequent public commentator on domestic and foreign events from Ottawa. So, Craig, we'll start with you.
Okay, yeah, thanks, Warren. I'm conscious that a law professor and a retired diplomat stand between you and the wrap-up and the wine and cheese. So, I'm going to try to be very succinct, especially since we've covered a lot of this terrain already today. I'm going to propose a few fixes, but first I'm going to set out my complaints. My complaints concern what I'll call generally the accountability system, and specifically that aspect of the accountability system that Warren has described as review. And so this is the backward-looking auditing function performed by a number of specialized bodies within our security intelligence service, designed to ensure that the agencies themselves comply with law and with ministerial directives, among other things. I am of the view that this accountability system in its present form groans, and the groans, in my view, are occasionally audible, in efforts to keep pace with the increasingly large-scale and integrated security operations of agencies like CSIS, RCMP, and Communications Security Establishment, or CSIC. CERC chairs resign in controversy. We've had 2 chairs resign in quick succession in controversy, some controversies more dramatic than others. The body CERC remains understaffed. It's staffed now at 3 members. We have an acting chair, not a full-time chair. The agency is deserving of resources. If you look at its resource allocation, it has not grown at the rate of growth that you've witnessed with CSIS. And the latest CERC report, again, CERC is the body that reviews CSIS, the latest CERC report, which came out rather late on Friday, suggests that all is not well in the world of CERC-CSIS cooperation, and for the second time now in less than a year, I've seen an accountability body complain that the service has not met its duty of candor in terms of its reporting to that body. And so the first time was the federal court, now we see a similar complaint from CERC. CERC and the CSIC commissioner, and so CERC and the person who's supposed to review our security intelligence, our signals intelligence agency, that is CSE or CSIC, when these two bodies tried to coordinate their review operations, they are reportedly criticized by the security services. In fact, from reporting in the Globe and Mail, that criticism took the form of CSIC complaining that there was some prospect that its review commissioner had violated his secrecy oath in trying to coordinate review functions with a CERC. Meanwhile, other important and powerful agencies like CBSA wander about without any review in the area of national security whatsoever. Parliamentarians, for their part, are blind and frankly, often oblivious, and no legislated committee of parliamentarians has attracted government support, despite private members' bills calling for such measures, including a private member's bill by Hugh Segal, which is being debated now as we speak, and I've seen some Twitter feed on this just during the course of this conference. Now, my view on this is that the review bodies need to be staffed. They need to be staffed earnestly, with at least some experts in the field, and at least some of those experts should have legal training. And that's actually been a phenomenon with CERC. There is actually a member now of CERC who has legal training, but that hasn't always been the case in the recent past. I know Alex and I have been waiting by the phone in anticipation of a call from the PMO, but it has not come. They also need to be staffed completely, not on a partial basis, which is a problem with CERC. And also, the CERC members should be full-time. This is a part-time position. And so you have now 3 part-time CERC members with a total staff of 17 whose role is to conduct review of CSIS. More than that, parliamentarians must be made relevant by enacting law projects like Bill C-622, which is actually a model for a legislative committee of parliamentarians, which I prefer relative to some of the other models that are out there. That's a bill that's been tabled by Joyce Murray. It incidentally would also extend a modified warrant provision to oversee CSIC intercept of signals intelligence, something when it implicates Canadians, something that's been controversial post-Snowden. And of course, turning to the topic du jour, I also believe that the government needs to enact the Arar recommendations, the ones from the policy report that Warren mentioned. Now, these recommendations, these are now ancient in relative terms. I mean, they predate the iPhone, let alone the iPad. And so one has to cast one's mind far back, but they are still relevant. In fact, they are more relevant than ever. And so we've talked about the idea Warren's raised of some sort of review body for the RCMP. We remain unable, it seems to me, to put into place a review body for the RCMP that actually meets the standards and expectations that Justice O'Connor proposed. Not least, the model that's currently being debated would allow the review body access to so-called special operational information only through a complex adjudication process that would require the input and the blessing of a retired judge. This is not a model where the review body would have access to secret information easily. Justice O'Connor also proposed that there be review for the other branches of government that engage in national security. I've mentioned CBSA, but there are others. Warren alluded to the phalanx of agencies that do national security, everything from FinTrack to Foreign Affairs. We have not made any progress on that. And as I've noted, CBSA is calling out for review, not least because we now have new powers of citizenship revocation that will come into play, and I would imagine that CBSA will be involved in the exercise of at least some of the intelligence that goes into that particular operation. And then the final recommendation, and I would argue probably the most important recommendation that's been ignored, is the idea of coordination and collaboration between the review bodies. That was review, or that was recommendation 11 for those of you who are interested in looking it up. Again, no action. And media reports, as I've suggested, suggest that whenever review bodies move on their own to coordinate, at least to coordinate in relation to secret information, they get slapped on the wrist by the security services that they're supposed to be reviewing. So review remains dangerously stovepiped, even as security intelligence efforts are directed at becoming more seamless. And domestic coordination is one thing. I have seen no indication that there is serious international collaboration between the review bodies of various states, despite the Five Eyes relationship, about which we've heard some talk today, that webs Canada into a network of intelligence sharing. And in fact, when I've raised this idea of borderless review with review bodies at their conferences, they look at me blankly. And when I raise this with the lawyers for the Five Eyes intelligence agencies, they become very animated in the criticism of this idea. So just to end then my observations, especially on this issue of the need to coordinate review, let me point to a decision by Justice Mosley of the Federal Court in 2013, about which many of you are familiar. That is the one that criticized CSIS for collaborating with Five Eyes allies in terms of surveying Canadians located overseas. Justice Mosley concluded that that overstepped the warrant permission that the CSIS had. He wrote, Justice Mosley did, a stinging critique, but he only learned of this operation through happenstance. That is, he read the review report of CERC, he read the review report of the CSIC commissioner, and he realized that in fact these operations had invested and involved Five Eyes allies, something that he had not anticipated. But more than that, he realized that CERC and the CSIC commissioner didn't really understand what the warrant authorization actually was. Here's what he said. CERC is operating under the mistaken impression that the warrants issued by this court authorize the collection of intercepts respecting Canadian persons by foreign agencies. In doing so, the court is associated with the concern identified by CERC that the ability of a Five Eyes partner to act independently on CSIS-originated information carries the risk of detention or other harm to a Canadian person based on that information. And then he goes on to allude to past royal commissions that have pointed to the danger of unsupervised information sharing. In other words, an allusion to the Arar case, the source and the inspiration for this conference. And in fact, that concern about intelligence sharing is more acute now that we've moved from a system of extraordinary rendition, pernicious in its own right, to one in which certain allies deploy drones for the purposes of eliminating security risks on the basis of intelligence information. And that statement by Justice Mosley underscores to me the importance of robust coordination between review bodies so that they understand what each of them knows to better do their function. Otherwise, we're left with haphazard and approximate review, and accidental accountability is not sustainable. So let me end there.
Very good. Our Pardy.
Thank you, Mr. Chairman. It has been a long day, and I'll try not to keep you beyond 5 o'clock. And it's been even a longer week in the affairs of our country. The events last week and the two murders, I think, have provoked commentaries ranging, I think, from the ridiculous to the profound. Each in their own way provide a tragic backdrop to the substance of this conference. It is important, I think, as well, to dismiss the idea that something called Canadian innocence has been lost in the midst of these tragic events. Unfortunately, a Canada innocent from the troubles of the world is one of our national conceits that does not withstand close examination. A more telling observation about all of this, of course, relates to an ad that was placed in last Thursday's Globe and Mail. There were several pages of detailed and often inaccurate reporting of the events of the previous day on Parliament Hill. This was followed by an ad by the Toronto Dominion Bank for its Visa card program. In the full-page ad and in large print, the ad suggested we should get out of town. And in order to encourage us to do so, it was willing to give us 25,000 Aeroplan miles. I'm not sure whether many people in Ottawa or even in Toronto took the Toronto Dominion Bank up on that particular issue. And I don't think the editors of the Globe and Mail meant any apparent irony in the placement of that ad, but it is one that, if one follows, understands ancient Greek history, it is one that the Greeks would fully understand. At times, earlier today, my mind wandered back to when I sat in the witness chair with Justice O'Connor on one side, and Marlis Edwards and Paul Cavalluzzo out front, closely questioning me about my involvement with regards to getting Mr. Arar back to Canada. And there are days now, or nights now, when I can remember when there are nightmares when Paul Cavalluzzo and Marlis Edwards shows up in them. I keep referring to them as between the devil and the dark blue sea, but I don't say who is whom in that process. And Justice O'Connor, as he demonstrated here today, I think displayed the reasons why we as Canadians can put our trust and confidence in the bedrocks of our political system, the rule of law, and the independence of our judiciary. And of course, there are two Canadians, I don't know if Monia is here yet, but for which this conference is all about. And they symbolize, I think, an essential element in our society. Mihir and Monia symbolizes more than the conflict between the unchecked demands of our national security behemoth and the ability of Canadians to get on with their daily lives. They symbolize the need for a national collective will to restore some measure of balance between the needs of national security and the protection of our rights as Canadians. Even at this early date, the events of the past few days demonstrate the overwhelming need of such a balance. Just as well, the reactions of our government so far suggest that a rebalancing is totally unlikely. It's not as if these issues that we're coping with today are new. In 1947, the Taschereau Commission, I can still remember it, in the aftermath of the defection of Igor Gusenko, touched on the ineptness of our security organizations in coping with a changing world. And that was even before I was Canadian. Since then, there has been a series of such commissions, starting with the Mackenzie Royal Commission in '68, and as was referred to earlier today, the MacDonald Commission of 1981, and others have followed. And of course, we've heard from Justice O'Connor and the work that he did in the mid part of the last decade. And there is no doubt that there will be successor commissions. It is a well-worn tool of governments of all persuasions in all parts of the world to use members of the judiciary to deal with such matters and to give legitimacy to any responses that they make. And what is unfortunate in all of this is that the issue of the relationship of the individual to an ever-strengthening security leviathan becomes part of the longer term. And as already been noted, I have spent more than 40 years wandering the corridors of government, and I can assure you that in government, the longer term never arrives. A few years ago, a British writer had a character in one of his social novels remark, and quote, "I just saw somebody pee in Main Street. I am not sure if that is the end of civilization as we know it, or was it just somebody peeing in Main Street?" There is an extensive literature on the ability of governments to make a distinction between the claims as to the end of civilization and the ephemeral action of just somebody peeing in Main Street. The events of the last few days require that we make that distinction. I would go even further and suggest that our response to the pernicious evil of our age, the collectivity of disparate events known as terrorism, needs the early and firm administration of that distinction. Are we dealing with the end of civilization situation or just persons with weak bladders? Canadian governments over the decades have not distinguished themselves when required to make that distinction. Pierre Trudeau's statement to a reporter when asked how far he would go in dealing with apprehended insurrection in Quebec has become a classic. Quote, "Just watch me." It established a standard for politicians ever since. The detention of several hundred citizens at that time on little more evidence than that their names were French demonstrated just how far Mr. Trudeau was prepared to go. He provides a salutary lesson for today when persons with names such as Arar or Al-Malki or Abdel Razak, Banata or Kadar or Arkat fall within the ambit of our security organizations with the enormous personal and societal consequences. Prime Minister Harper's response, as you've seen over the last few days, has been a bit more nuanced than what Mr. Trudeau echoed back in 1970, I think it was. Supposedly speaking for all of us, he, with as much passion as he could muster, simply said that Canada would not be intimidated. He said this even before he had any sense of whether the murder of 2 soldiers was part of an orchestrated plan or the work of individuals with serious mental problems. The Prime Minister has made clear that he is not interested in causes when there is an opportunity to apply his well-exercised political stratagem of providing answers to non-existing problems. And even more sad was the testimony of the Commissioner of the RCMP when he appeared before a parliamentary committee on Monday. With some fanfare, he reported on a video prepared by the murderer of the young soldier at the War Memorial. The Commissioner stated that he put confidence in the fact that the murderer referred to Allah and gave a distorted view of Canadian foreign policy. This provided the Commissioner with all the evidence he needed to declare the event one of terrorism. If referring to the God of Islam, which most scholars would agree is not much different than the God of Christianity, and having a distorted view of Canadian foreign policy are sufficient grounds to declare an act of terrorism, then the concept itself is of less value than I ever conceived. On the foreign policy issue, most of the people in this room probably have a distorted view of Canadian foreign policy as it's practiced by this government. I know I do. Already, there is legislation before the Commons to give security organizations increased powers of preventive detention, restrictions on international travel, and the provision of information on Canadians to foreign governments. And as has been indicated earlier, there are plans to go even further. In this environment, it is foolhardy and perhaps even quaint to provide an assessment of the oversight and review mechanisms of our security organizations. The existing mechanisms are all characterized by 2 serious flaws which apply to all of them. The first flaw, of course, is the one mentioned by Craig. That is their mandates are weak and out of date. And the second flaw is that they all lack even the minimum resources for effective oversight. Added to these basic problems, there is the serious problem as to how governments appoint members to those oversight commissions. The sad episode of Arthur Porter suggests that his appointment, first as a member of the CSIS oversight body and then as its chairman, did not include any detailed investigation or understanding of his background. Dr. Porter is now a resident of a Panamanian prison, awaiting possible extradition to Canada, and that extradition relates to his activities in the construction of a medical centre in Montreal. It is a Panamanian prison that I have visited, and I would emphasize visit, on several occasions, and I can assure you that being a resident there is not a life-enhancing experience. A fourth factor that I would include as limiting effective oversight and review mechanisms, and this is the quality of the ministers appointed to head what is now called the Ministry of Public Safety and formerly known as the Solicitor General. Every minister appointed to this position is essential in ensuring that our security organizations understand they have a dual mandate. not only of national security, but equally the protection of the rights of Canadians. In the past 10 years, there have been 5 different ministers in this key portfolio. It is an understatement to suggest that they did not know what they were doing. Even CERC, the oversight mechanism Forcese, in its last report to Parliament was moved to write, quote, "CERC believes that many of the issues raised in this review go to the heart of ministerial accountability over CSIS." CSIS, in its reply, stated that written justification to the minister was still under consideration. Substantial ministerial responsibility has disappeared from our system. Only the buying of an overpriced orange juice in London is now cause for resignation. In all of this, Alice is alive and well. It might be comfortable to suggest that this is characteristic of our current problems and situation. That is not so. I can remember dealing with some of these matters with our current chairman back in the early 1970s. Mr. Allmand was then Solicitor General in the aftermath of the FLQ crisis, and without currying his favor or asking for further minutes, Mr. Allmand was the only Solicitor General that I've met over that period who understood the dual nature of his responsibilities. Another sad and neglected area of oversight and review for security matters is the role played by lawyers in our government. As most of you in this room have a nodding acquaintance with the legal profession know, you cannot administer the rule of law without lawyers, and today they are as pervasive in all aspects of the government process. I had 2 rules when I worked in government. The first was to ignore the advice of government lawyers and only listen to the accountants as to what was available in the till. But in the world of government, it is much more complicated. It's a much more complicated environment than those simple rules suggest. Many societies have given their legal profession preferential status in their own administration. This is especially so in the establishment of rules, not only in the area of overt conduct, but in the need to create respect for the law and its application. I would suggest that these rules are applied more in the area of those in the private sector than applied to those who accept the coin of the Queen. I would further suggest that this is an issue that all law societies might wish to examine, especially in the application of the rule of law in cases characterized as national security. It is not a stretch to suggest that the distinction between prosecution and persecution is thinner than it used to be. As we heard this morning, Omar Khadr will stand forever as an example of persecution at the hands of his own government. And in the United States, this issue has received more attention than it has here. J.S. Bybee and John C. Yu, both lawyers in the Department of Justice, were the authors of a legal opinion in 2002 that gave authority for the aggressive interrogation, that was the legal term in the States for torture, of a suspected operative from Al-Qaeda. In a detailed report, lawyers in the Office of Professional Responsibility in the Department of Justice there concluded that both lawyers had demonstrated professional misconduct. A second report was quickly ordered, and it rejected that conclusion. Rather, the new report stated that there was only flawed legal reasoning, and the 2 lawyers were not guilty of professional misconduct. And if you think that was the end of the story, I can now tell you that Mr. Bybee is now a federal court judge, and Mr. Yo, a professor of law at the University of Berkeley, the University of California in Berkeley. A few days ago, I was in Nuremberg and had that's Germany, by the way, for the younger people in the crowd, and had the opportunity to visit the courtroom in which several judges and legal officials were tried in the aftermath of the war. These trials, conducted by the victors, found most of the defendants guilty and established the principle that judges and legal officials do not owe a first loyalty to a government or to the state. Rather, their first loyalty was to the protection of citizens. It is today still a principle that is struggling for oxygen. But in the age of national security, in the age of the national security state, it is one that bears repeating. The creation of the International Criminal Court, of course, in The Hague more than 10 years ago now, finally gave international recognition to this principle. I would note that the court was largely due to the work of Philip Kirsch, a Canadian lawyer from Foreign Affairs and the court's first president. And he did most of the heavy lifting in terms of the creation of the court through an ongoing conference in Rome. And what it does demonstrate, and it speaks to the creative work that Canadians used to do in international affairs. Justice Iacobucci, in some of his comments earlier today, in terms of his inquiry, left out one important event when he, in his remarks, he issued a main report in October 2008, and in which he noted that the government objected to the inclusion of statements made by certain RCMP and CSIS officials. The government argued that the statements were injurious to international relations, national defense, or national security. To his everlasting credit, Justice Iacobucci refused to accept the government's assertion and took the matter to federal court, which gave authority for the publication of the statements. In a supplementary report, the statements by the RCMP and CSIS officials were published. They had nothing to do with international relations, national defense, or national security. Rather, the statements asserted that it was not the responsibility of intelligence or law enforcement officials to be concerned about human rights of Canadian detainees. It is sad to report that there is no evidence to suggest that it is now a responsibility of such organizations. A further, and this was examined in some detail by Paul Cavalluzzo in his presentation earlier this afternoon, a further matter that the legal profession should examine is the role of private sector lawyers in the preventive detention system known as security certificates. The Supreme Court, in its ruling declaring that the system was contrary to fundamental justice, it suggested, surprisingly, to the government that it might want to remedy that particular problem. It might want to adapt the system that the British had been using for some time by appointing special advocates. And as Paul made very clear in his presentation, even this, what was considered at the time an improvement on the situation for those who had been detained under the security certificates, this was of limited help to them. And I would suggest, and this problem has come up in the States in another context, and this relates to the execution of prisoners in certain states in the United States. The American Medical Association declared a number of years ago that its members should not participate in the execution of prisoners in the United States. I would suggest that lawyers in Canada might wish to give serious consideration to their participation in the Special Advocates Program, because their participation gives that program legitimacy that it would not have otherwise. And their withdrawal from this kind of system would see the collapse of that system. And I think it's fair to say, even though Paul is a special advocate, his comments about the weaknesses of that program suggest that it is no improvement over what was in effect before the special advocates were appointed. In all of this, I do not have any expectation that the existing system of oversight and review for security organizations can be improved to the point where it can be effective. The field is so vast, and with significant changes coming to meet the needs of new threats, the security organizations involved will never be current with the problems. There is, as Craig has already mentioned, there is little expectation that their mandates will be improved, the resources will not be increased, and the appointment process improved to even make the existing system meet the needs of Canadians caught in the national security webs. And it's more likely that the existing system will become worse. Even more pessimistic is that it is hard to envisage a successor government in Ottawa to the present one willing to act decisively in this sensitive area of governance. If you disagree with that assessment, I have an orange grove in Newfoundland that I will sell you. There is some irony in all of this. There is some irony. Pierre Trudeau established the political standard for reacting to national security problems. He also created CSIS on the recommendation of Justice MacDonald, but fortunately, he went even further. He gave Canadians the Charter of Rights and Freedoms, and it is this super law that Canadians increasingly use for protection against the excesses of our security organizations and our governments. And one further reminder to all of you, I'm always, and Alex has heard this one before, I'm always reminded of a saying by that great American philosopher of the last century. This was Pogo. We have met the enemy, and he is us. Thank you.
I think I should remind the audience that the International Civil Liberties Monitoring Group has gone before parliamentary committees on several occasions advocating strongly the implementation of Part 2 of Judge O'Connor's report, but without little success, as I said. But we've been there and pushing hard on this one. I also think it's important to recall that one of the main reasons, not all of the reasons, one of the main reasons Judge O'Connor recommended a comprehensive system is that he found during the work of the Commission that there were many joint operations between security and intelligence services. In other words, what they call NSETs, where the RCMP would be working in an operation with CSIS, maybe with the Montreal Police Force or the OPP and other. So if you have a system, he said, where you've got all these independent at arm's length oversight bodies, one for the RCMP, one for CSIS, another one with none at all, how do you get to the bottom of a serious problem where there's a violation of human rights or a violation, because their mandate is too separate and truncated. And so he wanted an oversight. And the reason, we must say, the reason that Judge O'Connor was so successful in getting to the bottom of the Arar tragedy is that he, as he pointed out, had a mandate to look at everything. Look at all these intelligence and security operations, to look at the consular service of the Foreign Service. He could go everywhere, and in this comprehensive way, he came out with an answer to what had happened and with strong recommendations. So this, as I say, this Bill C-42 is far, far away from what he recommended. We have about a few minutes for questions. I don't know, Rock, can I take a few questions? Rock, it's about 3 minutes to 5. Can I take a few questions? Are there any questions? Yeah, we'll take a couple. Yes.
Hi there. This is a question for Mr. Pardy. In another memo that Donald Rumsfeld received, he was told by the Department of Justice that the practices at Gitmo were likely not lawful, to which Mr. Rumsfeld responded in a memo, "Then find me a lawyer that says it's lawful." What does this say about the rule of law and those caught in its structured violence who are consistently told that their detention and cruel and unusual punishments are both constitutional and lawful?
I would argue that is not the application of the rule of law. That's the application of a government that basically is seeking vengeance and retribution on its own people. It is not one that is looking for, in effect, some method of justice that deals with these cases on their own merits. There's more ideology involved right now, and with the current minister, Peter MacKay, I mean, I'm sure he's the most ideological justice minister we've ever had in the history of Canada, and that covers a lot of territory. Yeah.
Yes, sir. Anybody else? Yes.
If Mr. Forcese could speak a bit about the proposals before Parliament right now for greater oversight. You touched on it a bit, but if you could expand as to which looks better or if any of them have any possible benefits.
Craig, I think, yeah.
C-42, I guess.
Yeah. 44, is it?
44.
Sorry, there's lots of proposals before Parliament. Are you talking about the various proposals for a review committee of parliamentarians, or are you talking about the CSIS Act amendments, or the review committees? So Wayne Easter has a bill, Huey Siegel has a bill, and as I mentioned, Joyce Murray has a bill. They're to varying degrees building on precedents from namely the United Kingdom, and to a lesser extent from Australia and New Zealand. My personal view is I quite like the Joyce Murray bill. For me, the litmus test is, can the Committee of Parliamentarians, subject to controls on what they can do with the secret information, can they compel the provision of secret information in the course of conducting their review? And so if you're going to assess the bills in terms of the powers they give to this Committee of Parliamentarians, I would rank Murray first, then Siegel, and then the Easter bill. And if you look at what the Australians are doing, one of the complaints that the Australian Parliamentary Review Committee has raised is that they don't actually have they're a good model in many respects, but they don't have quite the sorts of powers to compel the security services to cough up confidential information as they wish. And so it seems to me, unless you can slay that dragon, the risk is that you'll end up with a thorny debate about whether the parliamentarians can actually perform their functions. Sure, you can then layer on obligations that they can't disclose subsequently, but unless they have actual access to information, then we're going to end up with the same sort of debate that Justice O'Connor described in terms of getting to the bottom of the Arar matter. That is, if you don't have the information, you can't actually follow the trail of crumbs to arrive at core facts.
I should point out, while I would strongly support, as a former parliamentarian, the parliamentary committee such as Joyce Murray is proposing, I don't think it's enough. I think we could do with both. We should have the Parliamentary Committee on National Security and a comprehensive body such as proposed by a system proposed by Judge O'Connor with powers to get the information, to act, to force, to really do proper oversight. So I would like both.
Certainly not. My support of the parliamentary provisions isn't about then eradicating CSIC Commission or CERC. They perform different functions. Yep. And if anything, the virtue of a Committee of Parliamentarians is that you then enhance internal, in-house institutional knowledge in Parliament, which is sadly lacking, in part because of the churn in parliamentarians on the standing committees. And in fact, I would say in terms of ranking the most impressive existing standing committees, I would rank the Senate ahead of the Commons because there's more continuity, or there has been more continuity on the Senate, ironically, for reasons we all know, than there has been on the Commons. And that sometimes shows in how willing they are to press lines of questioning.
Comment on this. Yeah, another comment on this, and I mean, we all see the operation of a system in the United States where Congress, both the House and the Senate, both have committees that have extensive authority and power in this area, and they act and they use them. And that's where, but the American system is not the Canadian system in the sense of their willingness, in effect, to go beyond the most recent fight between, I think it's the Senate and the CIA, where basically they were taking each other to court. So in order to get the information that the Senate committee thought that it needed. The last time it worked, it was a couple of committees back in the 70s, in the aftermath of the Vietnam War, where in effect people were just tired of what the government had been doing and were quite willing to listen to, what was it, the church and what was the other committee in Congress? I forget, there was two of them. But they all made recommendations, and they're the ones that sort of released the information about what were known as the CIA family jewels, about every bad operation that they had in the history of the organization. But the difference between Canada and the United States in this area is profound. And to expect, I've seen no evidence in any parliament that I've watched where in effect a parliamentary committee would be effective in this area.
So with that remark, we'll close this meeting, and I invite Alex to come up and tell us what's next. Thank you to both.